The First Amendment protects the right to freedom of speech and press. Regulations that infringe on this right are often unconstitutional unless they fall into a category of speech that the government can regulate, i.e., false commercial speech, fighting words, obscenity, etc., or survive strict scrutiny. The government can show that the regulation is necessary to achieve a compelling state purpose. The government can regulate the conduct associated with speech with reasonable time, place, and manner restrictions. If the restriction applies in a public forum or a designated public forum, to be valid, the restriction must be content neutral and substantially related to an important government interest. If the restriction applies in a non-public forum or a limited public forum, to be valid, it must be viewpoint neutral and reasonably related to a legitimate government interest. In addition to regulation of conduct, the government can regulate content. However, content-based restrictions are presumptively unconstitutional. To be valid, a content-based restriction must be necessary to serve a compelling state purpose and narrowly tailored to achieve that purpose. Content-neutral regulations, on the other hand, must be substantially related to a legitimate government purpose and leave open alternative means of communication. First Amendment. Time/place/manner restriction. Proposal 2 regulates lighting for any and all sign placed on property. This is likely a permissible time/place/manner regulation. Time/place/manner regulations on speech are ones that are focused on the timing/placement of speech rather than the content/viewpoint of the speech. Time/place/manner restrictions are permissible so long as 1. They are content neutral, 2. Serve an important government interest, and 3. Leave open alternative channels of communication. Said differently, these restrictions are subject to a form intermediate scrutiny. First Amendment. Prior restraints. Prior restraints on speech are regulations that prevent or burden speech from happening before it has occurred. Generally speaking, prior restraints on speech are disfavored. Proposal 3 contains a licensing restraint that would require citizens to receive a license prior to installing lighting signs on their property. Prior restraints may be upheld so long as the standards for the restraints contain definite standards and don't allow for unfettered discretion in its application. Definite standards require that precise procedures be followed so that the people/public officials issuing the licenses do not have any room to exercise discretion in deciding whether to issue the license. Commerce Clause. DIPA is a proper exercise of Congress's commerce power. Like its taxing and spending power, Congress has a near-plenary power to regulate interstate commerce in the United States under the Commerce Clause of Article 1. This includes the power of Congress to set limitations on the use of commerce and the means and instrumentalities of interstate commerce that are rationally related to a legitimate government purpose. Means and instrumentalities of interstate commerce include roads, waterways, and vehicles. In addition to regulating interstate commerce itself, the Commerce Clause also permits Congress to regulate non-commercial activities that substantially impact interstate commerce in the aggregate. However, all of Congress's powers are subject to laws against discrimination, as will be explained below. Anti-commandeering. Furthermore, under federalism principles, the federal government may not commandeer the instrumentalities of the states. In other words, the federal government may not utilize their legislatures or agencies to enforce a federal law. This rule was developed by the Supreme Court in the case of Brady, where the federal government tried to force 24 states to use their police forces to conduct background checks on potential gun owners in order to enforce a federal gun regulation. Sovereign immunity. The state of FL may sue, through its Attorney General, for relief from unconstitutional legislation. To prevail, they must have standing and also assert a cognizable case against the government. The government is not immune from suits by the states in federal court, and the proper forum for an action between the state of FL and the United States would be the U.S. Supreme Court, who has original jurisdiction under the Constitution to hear a case between a state and the federal government. Any legislation that is constitutional at the federal level and conflicts with state legislation preempts the state legislation to the extent of any conflict. Federal acts which require a state to enact legislation may be unconstitutional as a commandeering of a state legislature to act. This is because of the protections of federalism in the U.S. Constitution, which prohibit the federal government from requiring states to enact legislation. However, the feds may condition certain funding on the passage of constitutional legislation. The U.S. Constitution requires standing, in addition to having a live case and controversy to allow a federal court to adjudicate the action. Bicameralism. Legislation of the United States works similarly to state legislation. There must be bicameralism, which means that the bill must originate in one house and pass in both houses by a simple majority. Additionally, there must be presentment, where the passed bill is presented to the president for signature. A president may choose to sign or veto a bill, and in the event of a veto, the Congress may repass the legislation over the president's veto by a 2/3 majority. Legislation that has not passed by one of these two methods is not current and enforceable legislation. Privileges and Immunities Clause. Privileges and Immunities Clause, because it seeks to discriminate or distinguish on the basis of in versus out-of-state residence on the issue of economic activity/livelihood. States may not discriminate on the basis of state residence absent a compelling and legitimate governmental interest, and if the mechanism employed is narrowly tailored and required to achieve that end. Perfect tender. Under the UCC, the perfect tender rule generally applies, unless it is an installment contract. When a seller tenders goods that fail to conform in any way to the underlying contract, the buyer typically has three options. She may 1. Accept the goods, 2. Reject the goods, or 3. Accept in part and reject in part. The buyer is entitled to sue for damages for any non-conforming goods, regardless of whether they are accepted. Third-party beneficiary. An intended beneficiary of a contract has the ability to sue the parties to the contract to ensure its enforcement or otherwise collect damages. And the intended beneficiary's claim is subject to the same defenses as might be asserted against the parties. Intended beneficiary. Moreover, FB was the intended beneficiary. Two parties can agree to benefit a third party, and if that third party is an intended beneficiary, then that third party can enforce the contract. Mixed contract. The agreement is a mixed agreement of intellectual property, patents, and licensing of the kits, and a contract for the sale of goods. The UCC covers the sale of goods which are tangible movable property. DNA kits are movable goods and therefore subject to the UCC. SF applies to contracts for sale of goods that are more than $500 in value. Merchant confirmatory exception. Under the UCC there is the merchant's confirmatory memo exception. Under this exception, if the merchant receives a memo from the other party confirming the terms of the agreement and does not object within a reasonable time, this writing may be used against him, her/it to satisfy the statute of frauds. Disclaimer of warranty. Warranties may be disclaimed, but generally such disclaimers must be specific and not hidden. When a disclaimer of a warranty contradicts an express warranty, moreover, the contradiction is resolved in favor of upholding the warranty. A generalized disclaimer, such as is often insufficient. This particularly applies to consumer goods, goods for personal or household use, such as a baby grand piano. Attempted murder. Attempt is an inchoate offense. To be guilty of attempt, one must commit a substantial step towards committing the crime. At common law, murder is the unlawful killing of another with malice aforethought. Murder may be committed if the defendant 1. Intentionally kills or causes great bodily harm to another, 2. A killing during the course of an enumerated felony, battery, arson, assault, robbery, rape, kidnapping, drug trafficking, 3. Murder in connection with drug trafficking, and 4. Depraved heart murder, which is a killing involving reckless indifference to human life. Murder also requires actual and proximate causation. Actual causation means that but for the defendant's act, the crime wouldn't have occurred when it did. Proximate causation requires the harm to be foreseeable. Accomplice. Under Florida law, an accomplice can be held liable to the same extent as the principal, David, if the accomplice offers encouragement to the principal who is committing the crime. Accessory before the fact. An accessory before the fact, which is when any person aids another in the future commission of a crime. The aid here was the location of the wire and instructions on when to go steal it. This is also an inchoate crime which merges into the completed offense and would merge with the conspiracy and theft charges. Common law murder. Under the common law, murder is the taking of a human's life with a depraved heart. Florida has adopted the common law definition and further calls murder that is not premeditated or deliberate as second-degree murder. Depraved heart is evidenced by 1. Intent to kill, 2. Intent to commit serious bodily injury, 3. Super reckless disregard of the dangers to human life, or 4. As a result of a non-prenumerated felony. Involuntary manslaughter. Evidenced by 1. A killing committed during a misdemeanor or a crime not classified as a felony, or 2. Reckless indifference to life that lead to death of a human. Possession of a controlled substance. Florida makes it a crime to knowingly transport, sell, or possess a controlled substance. Insanity, not in theory. Must be proved by clear and convincing evidence and raised by the defendant with the burden of proof on the defendant. Insanity means that the defendant did not have the legal capacity of mind at the time the crime was committed to be charged. The not-in theory follows that because of a disease of the mind the defendant did not know her actions were wrong, did not know right from wrong, or did not understand the unlawfulness of her actions. Transfer of deed. A deed transfer need not satisfy the statute of frauds, but the grantor must have the present intent to transfer, it must be in writing, signed by the grantor, name the grantee, contain a reasonable description of the property, and be witnessed by 2 attesting witnesses. Recording a deed is a presumption of the intent to transfer. Purchase money mortgage. A purchase money mortgage exists when the mortgagee gave the loan that allowed the mortgager to purchase the property. A purchase money mortgage has a superior interest over other creditor interests. Mortgage transfer. Generally, when a mortgager transfers his interest to a new buyer before the mortgage is paid off, the buyer takes the property subject to the loan. While the lender may still foreclose on the property, the buyers will not be personally liable and do not need to cover any deficiencies. However, sometimes the buyers will agree with the seller to assume liability for the mortgage. Real estate contract. Alternatively, in a real estate contract, the statute of frauds may be satisfied by showing two of the following three facts. 1. Payment of purchase price. 2. Physical possession of the land. And 3. Improvements to the land. Easement by adverse possession. In order for this easement to arise, there must have been access that was hostile or adverse, continuous, open and obvious, and for the statutory period. In Florida, that period is 20 years. Adverse possession. An adverse claimant may also claim adverse possession pursuant to statute under color of title or without color of title. To prove under color of title, the adverse claimant must record the deed with the county clerk which purports to vest title in the adverse claimant. To prevail on a claim without color of title, the adverse claimant must make a return with the tax assessor and pay the taxes on the property claimed. Both under color of title and without color of title require the claimant to be in possession for 7 years. General warranty deed. A general warranty deed contains 6 covenants of title. 1. Covenant of season, which says that the owner actually owns the property he is seeking to convey. 2. Covenant of right to convey, which means that the owner has the right to convey the property he claims to own. 3. Covenant against encumbrances, which means that the seller guarantees that there are no encumbrances on the property that were not previously disclosed. 4. Covenant of quiet enjoyment, which means that the seller will not be ousted from the property by someone claiming paramount title. 5. Covenant of warranty, which means that the seller will defend from any suits brought by someone claiming paramount title. And 6. Covenant of further assurances, which means if the seller did not convey valid title, he will do whatever is necessary to do so. Special warranty deed. However, under a special warranty deed, seller only covenants that he or she did not convey the land to someone else and that he or she did not encumber the land during ownership. The facts state that seller delivered a special warranty deed. Intentional misrepresentation. Intentional misrepresentation requires 1. A false statement of material fact. 2. Scienter or knowledge of the falsity of the fact. 3. Intent to induce the other party to rely on the misrepresentation. 4. Justifiable reliance by the buyer. 5. Causation. And 6. Damages. Fraudulent misrepresentation. Fraud when there is 1. Active concealment of a latent defect in the property. 2. An affirmative lie. Or 3. Silence when there is a duty to speak. Scienter, knowledge of the falsity, must be proved and there must be justifiable reliance, causation, and damages. Defamatory statement. Fault. A public figure must prove that the defendant made the defamatory statement with actual malice, that is, knowledge that the statement was false or reckless disregard for the truth. If plaintiff is a private figure, then all they must prove is negligence. A public figure is generally a celebrity or someone who holds themselves out to the public or involves themselves in topics of public concern. Libel versus slander. Libel is printed defamation, slander is spoken. Slander requires actual proof of damages unless slander per se, while libel does not require such proof. However, libel by a media defendant does require proof of damages, and damages are never presumed. Furthermore, against a media defendant, the plaintiff can send a request for a retraction, and, if the media defendant complies, then plaintiff is limited only to actual damages. Qualified privilege. A qualified privilege exists when a statement, otherwise defamatory, is made by an individual in good faith, with an interest in making the statement, and limited in scope to the interest he has. Punitive damages. Punitive damages must be pleaded specifically and are permitted when the trier of fact finds that the defendant acted intentionally or with gross negligence. Punitive damages are capped at the greater of $500,000 or 2x special damages. In limited circumstances, when the plaintiff can show the defendant knew of the risk and decided to proceed for purely pecuniary reasons, the plaintiff may recover $2 million or 4x special damages. Malpractice. Where one sues a doctor for malpractice in Florida, there must first be a pre-suit investigation conducted prior to filing the suit. Before notice to the parties, the plaintiff must have a doctor investigate the cause of action to determine that it is legitimate. Then the plaintiff must provide notice to all parties involved, 90 days prior to filing suit. The notice must include the affidavit of the investigator. During the 90 days, the statute of limitations is told and the defendant investigates the action and determines whether he will offer settlement, deny, or admit liability and litigate the damages. If the parties determine to litigate the damages, then they may elect to go to arbitration. If arbitration is unsuccessful, then the plaintiff has 60 days or the remainder of the statute of limitations to file suit. In arbitration as well as in court, there is a cap on the damages recoverable in malpractice cases. If the plaintiff decides to go to court on the issue of damages and forego arbitration, then the cap is $350,000 as opposed to $250,000 in arbitration. The cap in court for a disabled person in an emergency setting ranges from $1.5 million to $500,000 depending on the damages. A practitioner must show that he behaved as a practitioner in similar standing according to the similar community standard and acted accordingly as a prudent practitioner would. Florida also takes into account specialty. Double jeopardy. Criminal defendants have the due process right under the Fifth Amendment of the United States Constitution that they may not be placed in jeopardy twice for the same offense. This rule applies to the states through the 14th Amendment. Jeopardy attaches in a jury trial when the jury panel has been sworn in. Jeopardy attaches in a bench trial when the judge commences the proceedings. It is not clear whether this is a jury trial or a bench trial, but because the trial has clearly proceeded, jeopardy has clearly attached. Once jeopardy attaches, a defendant may not be trial again for a charge if the fact-finder makes a finding that the defendant is not guilty of that specific charge. Additionally, a defendant may not face trial again on that charge if on appeal a court of appeals finds that there was insufficient evidence to support the charge. However, if the trial is either abandoned for a mistrial, the defendant can be placed in jeopardy again for the charge. Additionally, if the case is appealed and a court of appeals overturns the case for any reason other than the sufficiency of the evidence, the defendant may be trial again. Motion: incompetent to proceed. If a defendant is found incompetent on the request of the defendant's attorney, the state prosecutor, or the court, the judge will stay the proceedings and order the defendant be evaluated by no more than 3, but no less than 2 mental health experts. Modification or termination of the trust without court involvement. After the death of the settlor, an irrevocable trust may in certain circumstances be modified without court involvement if all the trustees and beneficiaries unanimously agree that the trust no longer serves its material purposes. However, the trustee can deny such modification or termination if in good faith he or she believes that the trust still has a valid purpose. Judicial modification or termination of irrevocable trust. In addition to modification or termination through a trustee, beneficiaries where a settlor is deceased can seek judicial modification or termination of a trust that's purpose is materially being frustrated. The court must find that the initial purpose of the trust is not valid, not feasible, or not in the best interests of the beneficiaries based on the current situation that was not considered at the time of trust creation. The court will look to the intent of the settlor both through express trust provisions and extrinsic evidence for guidance. Termination of a trust. A trust can be terminated when consistent with the settlor's intent. So long as the settlor is living, this may be done by consent of all the beneficiaries and the settlor. However, Sally, the settlor, is dead. When the settlor has died, the trust may be terminated by unanimous consent of the trust beneficiaries so long as doing so would not conflict with the material purpose of the trust. Among material purposes for trusts are spendthrift clauses or other clauses designed to limit the discretion of the beneficiary to dissipate trust assets. Exculpatory clause. Exculpatory clauses in trust can relieve the trustee of liability. However, if the exculpatory clause is found to have been a result of undue influence or the clause is one that prevents the trustee from being liable for bad faith/reckless behavior, the exculpatory clause will be found invalid. Trustee compensation. Trustees are entitled to reasonable compensation for administering a trust. The amount paid to the trustee is deducted from the trust res, 1/2 from principal and 1/2 from income. The amount of compensation can be set forth in the trust instrument. Simultaneous Death Act. Florida has adopted the Uniform Simultaneous Death Act, which states that if 2 people die at the same time, it is presumed for purposes of dividing their property that they survived the other. Florida has not adopted the rule that the spouse must survive the other spouse by 120 hours in order to take it out of the act. Charter County Authority. A charter county has the authority to make laws for the health, safety, and welfare of their citizens, provided that the laws are not preempted by Florida state laws. A non-chartered county will only have the authority to create laws pursuant to the authority granted by the Florida legislature. Access to courts. All citizens of Florida are entitled to access the courts without denial, sale, or delay. If the law denies access to the courts in some manner, the government must provide a reasonable alternative. If the law does not provide a reasonable alternative, then the government must show that there is a public necessity and no other reasonable means of addressing that necessity. Excessive bail. The Florida Constitution prohibits setting excessive bail. In fact, everyone jailed for an offense other than a capital or life felony has a right to pretrial release so long as they do not pose a risk of flight or failing to show up for their court date. They do not pose a risk to the judicial process or to the community at large. The bond condition in this ordinance requires a mandatory surety bond of $2,000 times the number of months a person was previously incarcerated, which is excessive. The bond is not related to a person's flight risk or their danger to the community. The bond requirement is also not related to a person's ability to actually post the bond. The bond would therefore result in more indigent and poor people being imprisoned than people who are not indigent or poor. The bond provision would thus violate the Florida Constitution as an excessive bond. Ex post facto clause. The ordinance punishes activity that occurred before the ordinance was enacted or before people had a reasonable chance to become aware of the requirements of the ordinance. That is, the ordinance punishes living within a certain distance of a school, with no provision that the ordinance could only be enforced for violations which occurred after the ordinance was enacted. To be properly enacted, legislation must contain a short and simple statement of its purpose, contain only one subject matter, must contain a description of the law that is easy to understand, and must contain enacting language indicated that is enacted by the Florida legislature under the authority of the state of Florida. Similar requirements may be applied to the Board of Commissioners and their ordinances. The ordinance in this case would probably meet basic requirements. Home Rule powers. Under Home Rule powers, a municipality/county in FL can enact ordinances relating to the health, safety, welfare, and morals of the people. However, such ordinances must not violate the FL or U.S. constitutions, nor be preempted with the same. The First Amendment of the U.S. Constitution, applicable to the states through the 14th, protects the freedom of speech and association and the free movement of ideas through society. Right to keep and bear arms. Like its federal counterpart, the Florida Constitution does protect this right. Specifically, it provides that the right of the people to keep and bear arms for self-defense and defense of the lawful authority of the state shall not be infringed. But it adds that the manner of regulating the bearing of arms can be regulated. That sounds bad for this law, arguably, but the courts have interpreted this provision relatively lax in practice. Specifically, they have held that guns commonly used in criminal enterprises can be banned by the legislature, that the legislature has broad authority to regulate with respect to other firearms, while suggesting that the legislature might go too far if it were to ban common firearms. Kluger test. The Florida Constitution guarantees that the courts will be open to all, without sale, denial, or delay. The Florida Supreme Court has developed the Kluger test to determine when that right has been violated. Under the Kluger test, the legislature may not close the courts by abolishing causes of action that otherwise exist unless 1. It provides a reasonable alternative, or 2. The government can show that the law serves an overriding public need that cannot be met with any other alternative. City ordinance. Cities, also known as municipalities, if incorporated, which this one seemingly is, have the right to create ordinances based on police powers and the state in general for the health, safety, welfare, and morals of Floridians. Municipalities and chartered counties can create laws that supplement the general and special laws that the state legislature has created. On the other hand, unchartered counties would not be able to do so. They are limited specifically to those general and special laws. But municipalities can create laws for the police power of protecting their citizens and will argue that this falls into it because it is specifically to fight crime and reduce juvenile crime and the consequences thereof. Local government encroachment. Article 5 spells out the jurisdiction of the courts in Florida. It states that the legislature is not empowered to endow judicial power to the executive beyond levying certain, as in specific, legal fines. The exception is that the legislature can establish a civil traffic infraction quasi-court system. When a governmental entity, a branch of government, takes some authority from what is rightly endowed in another branch, then that is considered encroachment. Encroachment by local government, like administrative entities taking on judicial functions, has been and will be considered unconstitutional. Broward County. Mayoral appointment. In local government in which quasi-legal decisions are made, like in traffic fines, it is unconstitutional for the mayor to have an intimate process in the administration. For example, it has been held unconstitutional when a mayor served as the county fines determiner and also was able to allocate that money from the fines. This governmental entwinement between the city's/county's executive and the judicial system will be struck down. Governor powers. The governor has the authority under the Florida Constitution to call a special legislative session. Special legislative sessions must be limited in scope, and in the absence of the requisite vote of the members of the House and Senate, 2/3 vote, no new matters may be addressed during a special session other than those for which the special session was called. FL statute formalities. First, the act includes a short title that sufficiently describes the subject matter of the law. Second, there is an enacting clause. Finally, the purpose for the act was likely in accordance with the legislature's authority to pass laws for the general welfare, health, safety, and morals of the public, as the purpose of the bill deals with litigation efficiency and raising revenue, though the means by which these purposes are achieved are questionable, as discussed below. However, the act likely violates the single subject rule. To comply with the Florida Constitution, a law must cover only one subject. Each component part or aspect of a law must have some natural relation to an overall scheme. Special law. A special law, unlike a general law, is a law that only applies to particular geographic areas in a state. Special laws are permitted, so long as voters in the effective area are given notice of the proposed law and a referendum is held. Additionally, a special law, as well as a general law of local application, which does not require notice and referendum, but applies to certain areas based on a classification scheme such as population, cannot cover certain subject matter that the Florida Constitution expressly prohibits. Such prohibited subject matter includes taxation, elections, petty juries, conditions precedent to bringing civil or criminal claims, venue rules, and rules of evidence. Ad valorem taxes. Normally, all municipality property is exempt from ad valorem taxes. However, when deciding if the municipality property is exempt from ad valorem taxes, you must look to the government purpose v. commercial purpose test. If the land is being used for a private purpose, it is not exempt from ad valorem taxes. On the other hand, if the property is being used for a government purpose, it will be exempt from paying these taxes. Membership right. In Florida, The right to work is an enumerated right in the Florida Constitution. These rights are looked upon as fundamental rights. In Florida, one may not be granted or denied work based on their membership or non-membership to a union. Florida government bonds. In Florida, there are two types of bonds that may be issued in order to finance government projects. General obligation bonds are bonds that repayment is guaranteed by the full faith of the government. In order to pass a general obligation bond, there must be a referendum by the people on whether it may issue. Things such as schools and bridges require no such vote. Revenue bonds are bonds that are paid back from the revenue that the project generates. Municipalities may issue a bond without a vote if it matures within 1 year. General laws/special laws. The full faith of the government. In order to pass a general obligation bond, in order for the legislature to pass a law, it must be passed in a legislative session. Laws must have a title that gives notice and is not confusing, contain a single subject, and must contain an enabling clause that reads, "Be it enacted by the legislature of the state of Florida." General laws are laws that cover everyone in the state even-handedly and only require passage of the Florida legislature. A special law is one that applies to only a certain person or groups of persons or a certain geographic area, such as a city. Special laws require either notice before the passing or a referendum after the passing, or the law will have no effect. General laws of application are laws that are general laws that apply uniformly to an area, such as one that has a minimum or maximum population requirement. A bill of attainder. A bill of attainder is legislation that attempts to impose a punishment on someone without the benefit of a judicial determination. Modification of time sharing. In Florida, the default time-sharing setup is an equal sharing of time, since it is presumed that parents should equally share the joys, responsibilities, and rights of raising a child. This default can be deviated from when that would be in the best interests of the child, i.e., equal time sharing would be detrimental, or the parties agree to it. As the parties' agreement can be adopted into a dissolution of marriage order as it was here. When a dissolution of marriage order includes provisions regarding time-sharing, those provisions may be modified upon a showing of a substantial change in circumstances from the time when the order was entered. Modification of child support. Like with time-sharing, modification of child support also requires showing a substantial change in circumstances. A change in income that would lead to a 15% or $50 increase in child support obligations is typically found to be a substantial change in circumstances. If mother is correct and father's income has nearly tripled, a 15% or $50 increase would likely be found, and the court would likely grant modification of the child support order to have father pay more child support. Notably, child support is intended to put a child in a position to receive the same split/amount of resources from the parents as the child would if the parents had remained married. A goal which would be met by increasing the child support father must pay if his income has come anywhere close to tripling. The beneficiary of child support is the child, so parents may not waive child support on a child's behalf nor agree to a reduction below the amount to which a child is entitled. The anti-modification clause would result in the latter, since it would prohibit child support from being increased to be congruent with child's needs and best interests. Modification of alimony. As an initial matter, unlike child support, alimony is a spouse's benefit to waive, so the clause prohibiting modification may be enforceable to prevent mother from modifying alimony. Such a clause may be enforceable if it is reasonable and agreed to by both parties, both of which appear to have been here. If the anti-modification provision is not enforced, mother may be able to modify alimony if she can show a substantial change in circumstances has occurred since the order set the alimony. Since alimony is largely based on a balance between the payee spouse's need and the payer spouse's ability to pay, father's alleged large increase in income would qualify as a substantial change in circumstances. Termination of parental rights. Termination of parental rights is considered a serious action and will be presided by a judge and fully adjudicated, even though it is a civil proceeding. The circuit court will have exclusive jurisdiction over such proceedings. Parents facing a TPR are protected by the Due Process Clause of the United States Constitution and by Florida Constitution. The U.S. Constitution guarantees parents facing a TPR the right to counsel, goes beyond statutory right under Florida. Further, the government must prove its case in a TPR by clear and convincing evidence. This is a higher standard than the preponderance of the evidence standard required during shelter and dependency proceedings. During a TPR proceeding, notice must be given to parents, to grandparents, to guardians, and to any other that has possible custody rights to the children. If the state effectively files a TPR petition, that parent's rights will no longer exist, and in the face of the law that parent will have no legal relationship to that child. TPR is an individual process, and as such each parent is independent of each other. Filing of termination of parental rights. A TPR may be filed at any time. However, in Florida, DCF must file a TPR when 1. Parent has been under a case plan for more than 12 months and not met the requirements. 2. The children have been dependent for 12 months out of the last 22 months. 3. When parent has killed or attempted kill other parent or children. 4. When parent has been sentenced to incarceration, which will last through the substantial part of the child's youth. 5. Parent has failed to comply substantially with case plan. And 6. When it finds that there is good cause for initiating the proceeding. TPR can occur because a parent has abandoned the child, for abuse, for neglect, but this must be shown by preponderance of evidence. Adoption. After Obergefell legalized same-sex marriage, same-sex couples became entitled to many of the same fundamental rights as heterosexual married couples, such as the right to marriage, divorce, and adoption. Even before same-sex marriage was legalized, same-sex couples were entitled to legally adopt a child. In determining whether a person is able to adopt a child, the court looks at the fitness of the person to be a parent, her home environment, her work schedule, her ability to provide for the child, and many other factors. Adoptions may be granted for married couples or single parents. When a person/family applies to adopt a child, the state conducts a background check on all members of the household who are aged 12 or older. After the background check comes back clear, the state then interviews the parents-to-be and conducts a home study to ensure a safe environment for the child. Following a successful home study, the parents wait until a child is placed with them. The child is placed with them for a period of time, generally around 6 months or longer, to ensure the match is a success. This time is called adoptive placement, and during this time the parents-to-be and the child make sure that everyone is happy with the placement. The state makes routine checks on the child to ensure everything is going well. Finally, once the placement seems appropriate, the parents-to-be may petition for the adoption to be finalized. The judge generally grants this petition in chambers, so long as it is clear that the adoption is in the best interests of the child. Relocate with kids. If one spouse intends to move more than 50 miles away, he or she bears the initial burden of proof. She must show that based on numerous factors, such as job opportunity, child's choice, depending on age, and other such factors. If moving, the moving spouse must provide the new address, how time sharing will continue to work, among other requirements. The burden then shifts to the opposing parent to show why the move would be improper. Jurisdiction. In order for a party to file this type of action in a Florida court, the party has to be living in the state for at least 6 months. In order for the court to have personal jurisdiction over the opposing party being served, the party must either be a resident of the state, or there must be a basis for personal jurisdiction pursuant to Florida's long-arm statute. Florida's long-arm statute analyzes the party's contracts in the state, for example, whether the party owns property or does sufficient business in the state. When an action involves a child, jurisdiction will be based upon the Uniform Child Custody Jurisdiction Enforcement Act, UCCJA. The state that issued the first order regarding the child will always have continuing jurisdiction to modify it. However, jurisdiction could also be established in the state where the child and at least one parent have resided for the last 6 months. If this cannot be established, Florida could still take jurisdiction if no other state wanted to take jurisdiction of the case. Conflict of interest. A lawyer has the duty to provide diligent and competent representation to its clients. Part of providing diligent representation is avoiding conflicts with former, prospective, or current clients. A conflict exists when representing one client would impede effective representation of another client, or would involve the disclosure of confidential information that must be protected. Normally, a lawyer cannot provide representation to a prospective client concerning the same or a substantially related matter in which that lawyer represents a former or current client with adverse interests. Within a firm setting, a conflict that one lawyer has in a firm is imputed to the other lawyers working at the firm. Therefore, the fact that another lawyer in the firm represented Chipco would be imputable to other lawyers in the firm. If a conflict does exist, then a firm may still provide representation if 1. Diligent and competent representation can be provided to both affected clients. 2. The representation does not involve representing both clients with adverse interests to one another in the same proceeding before a tribunal. And 3. Both clients provide their written and informed consent. Attorney advertisement. The Florida Rules of Professional Responsibility states that advertisements must contain a disclosure in red that it is an advertisement on the envelope and first page. The ad cannot guarantee results or make misrepresentations. Ex parte communication. Additionally, in a pending matter, communicating with the judge assigned to the case without opposing counsel present for the conversation, when that communication is about the case, is an impermissible ex parte communication. Any conversations between attorney and the judge in this case, without opposing counsel present for the conversation, would be an impermissible ex parte communication. Withdraw. An attorney cannot represent and must withdraw if a client is using the lawyer to commit a crime. The lawyer could not represent A if A were using the lawyer to commit perjury. In such a case, the lawyer either cannot take the case or, if he already has, must try to withdraw. If he cannot withdraw, he must disclose the perjury to the court. If the client is committing the crime without the lawyer's services, the lawyer is not required to withdraw, but may unless the court orders her not to. Acquiring an interest in the litigation. The FRPC states that a party must not acquire a property interest in the subject matter of the litigation. If I were to accept the payment of 15% of any assets awarded to W, this would be considered acquiring a property interest in the subject matter of the litigation.